A very good evening to all in this region, and to those in different parts of the world, good morning or good afternoon. Welcome to this webinar organized by the International Malaysian Society of Maritime Law on ship arrests, sham and facades of ownership. My name is Trishilia. I serve as the Secretary of IMSML, and I will be your moderator for today. I have with me here two speakers who will help us navigate the dark labyrinth of sham setups and facades in vessel ownership, and give us some tips on how to unmask the true beneficial owners of vessels. Identifying beneficial ownership, as many of you may know, is particularly important in jurisdictions where beneficial ownership is required to establish admiralty jurisdiction and give the right of arrest of vessels. Our first speaker, Tian Singh, will speak on the beneficial ownership requirement in ship arrests and the arising legal considerations. Tian Singh is an established maritime practitioner with over 20 years of experience. He is noted for his ability to handle transactions involving highly technical issues and is regularly instructed by clients in the shipping, oil and gas, international trade, and insurance industries. Our second speaker, Nathan Wilhelm, is the founder of Lhasa Services Limited in Hong Kong. Nathan started his career as a deck officer at sea and then became an accountant. These skills make him particularly suited for the maritime credit assessment industry, and he has been active in corporate investigations since the early 90s. Nathan will be speaking to us on the what, why, and how of uncovering beneficial ownership. We have a very interesting session in store, but just before we begin, please note that should you have any questions to pose to the speakers, please drop them in the Q&A box and I will have the speakers answer them as the webinar progresses. I will now invite Tian Singh to speak to us on the topic of the beneficial ownership requirement in ship arrests and the arising legal considerations. Over to you, Tian Singh.
Hi, good afternoon, everybody, ladies and gentlemen. I'm Moon Tian Singh, and I'm a partner in the firm TS Woon & Partners in Malaysia and Woon & Bazul LLP in Singapore. So I practice both in Malaysia and Singapore in terms of in the courts of both jurisdictions. As I mentioned, I'm quite long in the tooth in terms of shipping practice. I've been around shipping matters since 1998, which is quite a long time ago. So and in fact, some of the cases in which we are going to discuss, in the dim mist of history, I've been involved in one capacity or the other. Okay, so perhaps I think it's a Friday evening, so let's. Is it a Friday evening? No, it's a Thursday.
It's a Thursday, yes.
But it's still
a long week.
Yeah, it's still an evening. So let's get into it. Okay, so I'll share the screen now, if I may. Okay, so I hope I have it. There's at least the cover page anyway. Ship arrest, sham, and facades. Is that what I'm sharing?
Yes, we can see that.
Yeah.
You just need to present.
Yeah, okay. So I'm sorry. This went so well when we were practicing. Sorry, wait, let me try again.
Nathan, I think you did joke earlier when we were having the test run.
We've used up all our good luck.
Have I got it now?
Yes, you have. Okay.
Okay.
Go ahead.
I do apologize for the technical difficulties. Okay, so before I get into the meat of it, I think it's important to set out some of the more, well, I mean, to some of you will be very basic thoughts about how the right of arrest, the right of arrest arises right? So in the Malaysian context, the Malaysian Admiralty law is basically an application of the UK Admiralty law. So Malaysia, in fact, applies directly for a shipping law, the maritime sections of the UK, well, now known as the Senior Courts Act of 1981, sections 20 and 21, right? So just very quickly moving on. So there are two main sort of criteria for you to arrest a ship. One, the first major criteria would be the subject matter of your claim. It has to be an admiralty claim. An admiralty claim is defined as one of the claims which are listed in Section 21A of the Senior Courts Act. So you have any claim to ownership of a vessel, co-owners, possession, any claim in respect of mortgage, and more commonly claim for damage received by a ship in a collision matter, claim for damage done by a ship, collision matter, right? Loss of life, tort claims, right? Any claim for loss of or damage to goods carried in a ship, things to do with the ship, a very common head of claim, any claim arising out of any agreement relating to the carriage of goods in the ship, charter party, bills of lading, claims of that nature, right? Salvage claims and so on. So this sets out the subject matter of the jurisdiction, which you need to place one of your claims within that subject matter, right? So I mean, and different jurisdictions, different Commonwealth jurisdictions have slightly different provisions, right? So for example, under M, any claim in respect of goods or materials supplied to a ship for operation or maintenance, right? Now under, let's say for example, under UK, under English law, under Singapore law, under Malaysian law, this would be a claim for goods and materials, but it would not relate to a claim for services, right? So for example, a claim by a ship manager would not qualify, right? But in Australia, they have decided to extend that jurisdiction to services as well, right? So, so there are slightly different formulations of these claims throughout the Commonwealth jurisdictions, where Admiralty jurisdiction is more or less based on the English history and practice, right? Yeah. So I mean, just more and more of these claims which would be considered an Admiralty claim. I think we'll probably be able to download this and then look at it at your leisure, right? The second important criteria is the ownership criteria. The basic idea is that the party which is liable to the claim must, at the time of the commencement of the claim, either be the owner, the beneficial owner of the vessel, or a charterer by demise, a bareboat charterer, right? And so this is where we come into the meat of what we are going to be talking about today, which is the phrase beneficial ownership, right? And that phrase is important because that imports the idea that a registered ownership is not the criteria, right? It is beneficial ownership, and the idea of beneficial ownership, of course, is that it imports the sense that you can examine the relationship between the parties, relationship between various actors in the drama to determine where the beneficial interest lies. Right? So it's no longer, it's not a situation where you just look up at the registry book like a piece of land, for example, right? And then the Admiralty jurisdiction then attaches whether or not the vessel is registered. No, it imparts an examination, or rather an examination is possible by those words to consider whether some other party, who is not the registered owner, may yet be liable as the beneficial owner of the vessel, right? And so, right. So I've gone ahead And this is basically, that's why I have underlined and in bold the words beneficial owner here. This is section 21. Right? So the ownership criteria, right? The words used in legislation is beneficial ownership, right? So, and this includes instances where ships have been spirited into a different legal registered ownership. The beneficial owner's ownership being retained in the party liable, right? So you then have cases which then go into what the owner did with the ship, how the owner treated the vessel, what were the circumstances that the new owner, which is now seeking to say that they are not liable and there's no admiralty jurisdiction, right, has obtained rights and title to the vessel, right? So again, the meaning of the phrase beneficial ownership, right? This is the judgment of Goff, as he was Justice, the E Congreso del Partido. The natural and ordinary meaning of these words used in the expression, the ownership is as vested in a person who, whether or not is the legal owner of the vessel, is the equitable owner of the vessel, right? The Singapore Court of Appeal also looked at this phrase, and it was defined as such ownership of a ship as vested in a person who has the right to sell, dispose of, or alienate all the shares in that ship. Right? Now, the registration, and then what happens now is that there may now be a difference in terms of the ownership between what is the registered owner of the vessel and what is the beneficial owner of the vessel, right? So registration of the vessel is not conclusive, and that is in fact in the cases, and then we'll discuss that a bit more. So in the Temasek Eagle, it is stated that it is a useful starting point in ascertaining beneficial ownership, right? But ownership entry of a ship registry is not conclusive of beneficial ownership, right? And so that was also the holding in one Malaysian case, Kawasaki Kisen Kaisha versus owners of the vessel Able Lieutenant, right? Okay, but the clearest elucidation of this principle I found is in fact in the Singapore case, the judgment of Justice G.P. Selvon, right, in the Kapitan Temkin, right? Now, perhaps just a very short diversion into the factual matrix. Now, after the fall of the USSR, the Ukrainian government, right, had a fleet of about 200 vessels, which they then put into a company called the Black Sea Navigation Company, right, the Blasco, right? Now, there was question marks as to whether it was the Ukrainian state, the country itself, that owned the vessel, or that the vessel was owned by what was the commercial operator of the vessel, the Black Sea Navigation Company. And so there were delays in payment, problems with, claims all over the world. And, there arose a series of cases in the UK and in Singapore as well as to whether the true owner of the ship is the Ukrainian government or the Black Sea Navigation Company, right? And so here, I'm just actually quoting because it is so clear and is so well written. The certificate of registration is important documentary evidence in deciding who the beneficial owners of a ship for purposes of jurisdiction are, especially when it is produced and relied upon on behalf of the state or the power which issued the certificate. Right? It is so important that, it is so because the certificate of registration is also a certificate of ownership. See Chorley and Giles shipping law, where it is stated that registration is also important as proof only, as proof of title. It is not conclusive, but furnishes at least prima facie evidence of the registered owner being the true owner, thus resulting in a shifting of the burden of proof. whoever without being registered claims ownership must display their prima facie evidence. And so that very clearly stated, if you have registration, that is not conclusive, but is prima facie evidence that the registered owner is the beneficial owner of the ship. And in legal terms, then what happens is that the burden of proof is shifted, right? It's shifted back to the party asserting the converse, the party which asserts that the beneficial owner is some other party. That party then has the burden of proof to displace what is stated in the registry. Right? The certificate of registration, and I quote further, adds Chorley and Zhao shipping law, fulfills to a certain extent the function of a title deed. In this sense, the certificate of registration is similar to a certificate of title issued under the Torrens system of land registration, which was replicated from the paradigm of the ship registration system. I'm not so clear about that. Anyway, the title evidence by the certificate of registration is similarly indefeasible, subject, of course, to rectification in cases like error or fraud. See the Binetta. Today, the certificate of registration fulfills the dual function of proclaiming the nationality and ownership of the ship. Thus, even though as a general rule, the entry regarding the ownership of a ship registry is not conclusive of who the beneficial owners of a ship are, for the purposes of Section 4 of the High Court Admiralty Jurisdiction Act, which is analogous to Section 21 of the UK Senior Courts Act 1981, which is applicable under Malaysian law. In most cases, it would be so. The purpose and effect of the use of the expression beneficial ownership, therefore, is to protect claims against fraudulent concealment and sham transfers designed to defeat a claim, and also to protect authentic owners who are not personally liable to the claimants. Hence, most applications which go behind the register will be by the claimants and not owners. In either case, there must be clear evidence to look beyond the registry and the certificate. Right. So, yeah, that passage encapsulates the issue before us, right? Now, ship owners are, some ship owners, I wouldn't say all ship owners, but some ship owners are by nature very entrepreneurial and a very creative group of people. And some ship owners are, have a bit less, how should I say, less respectful of their obligations to pay than others, right? So, and that's where and they are aware of these provisions which we have spoken about, that the right of arrest only arises when, at the time the action is commenced, the vessel is owned by the person, beneficially owned by the person or by the party that is liable. And so we have had, in my experience, we've had many sort of cases where after a vessel has incurred some liability, then we see quite clearly or quite quickly ownership changes, right? And so that's one dynamic which I think all shipping lawyers have, which is to say that we get instructions to file what we call a protective writ, right? Because the test of ownership is at the time when the vessel, when the action is commenced, the vessel must be owned by the person liable. So once you issue a writ, that's it, that's fine, right? That position is set, right? You are then able to arrest the ship when the vessel comes into your jurisdiction, right? Because at the time the action is commenced, the owner is the person liable. So even after the vessel changes ownership, after you've issued the writ, that doesn't matter because the Admiralty jurisdiction is preserved as if because at the time when the action is commenced, the owner is the party liable, right? So this is what we call a statutory lien. When a writ of summons is issued against a vessel, a statutory lien immediately arises in favor of the plaintiff against the vessel, right? So here, okay, then I think there's some discussion here with respect from this other vessel, Straits Bunkering, which is a Malaysian decision, right? In another context, I think it's in a tax context, right? But it follows Capitan Temkin, right? Able Lieutenant, in which I was involved in at the later part of that case in 2002, many thousand years ago. This is a case in which there was an arrest of a ship, and the defendant, a third party then alleged that it was the owner of the vessel. They entered an appearance to the action and sought to apply to strike out the claim on the basis that Admiralty jurisdiction did not exist against the vessel because the ownership had changed. Right, and so in this case as well, the able lieutenant also followed the Capitan Temkin, right? So, in fact, you have the words here, right? And thirdly, arrest of a particular ship spirited away into a different legal ownership. In the case of categories 1 and 2, it's my view that the burden of proof is on the plaintiff to show that the defendant is the registered owner of the vessel when the verdict is issued. Now, there are a lot of the being able to proceed against a vessel on the basis of the beneficial ownership, even though the registered ownership has changed, imports a lot of different sort of concepts, and in fact, in the cases that I've done, we've had to go beyond what is strictly sort of shipping issues, right? So you look at principles of trust and equity. You look at principles relating to fraudulent conveyances, to delay or defeat arrest of the vessel, or insolvency, right? Principles relating to the piercing of the corporate veil, right? Principles of law relating to transfer of goods and principles of estoppel, right? And so when you are presented with a case in which it is possible to make this argument, right? And I say it no higher than that. It is, in every case that you will get, you will only be able to say that it is possible to make an argument. Because at the point when, as lawyers, we are instructed, we will not know. We will not know that somewhere in Cyprus or somewhere in some boardroom somewhere, that somebody has concocted a transfer of ownership, a sham transfer, to defeat your claim, right? So at the point in time, you only have a suspicion that something like this may have happened, right? And then that is the beginning of the road, because then you have to investigate the circumstances under which the transfer took place, the documents which are said to evidence the transfer. You have to go search, you have to do searches at the ship registry. You have to take copies of documents from the ship registry to look at how the bill of sale was lodged, who signed the bill of sale, which was the company that signed it, which was the company that executed it, whether there was a true handover of the vessel, whether a fresh crew was appointed, right? Or under circumstances where the parties are very, very much related. And this is where Nathan will come in. And I have used Nathan for many, many cases. And this is where he will come in and pry into the relationships between the parties to see whether there is a link, whether there is a controlling mind behind the parties. So, I think I more or less covered this. I think what might be useful, is here. Now, there is an established jurisdiction, there's an established principle under which the court will decide the beneficial interest of a vessel has been retained in the party liable if the transfer of the vessel itself is considered a sham, right? A sham, meaning or sham or considered a sham transaction in which the true owner has not divested itself of the title and that the new registered owner is a mere tool, is a mere facade, right, of the true owner, right? So here, de Block, in Snook and London versus West Riding, acts done or documents executed by the parties to the sham, which are intended by them to give to third parties or to the court the appearance of creating between the parties legal rights and obligations different from the actual legal rights and obligations, if any, which the parties intend to create, right? A false label in which the express purpose does not correspond with the true purpose, right? So this is where, as I mentioned, the transfer of the vessel is purely, it is not a real substantial divestment of the title between parties at arm's length, right? This is a mere device to avoid liabilities. So a standard of proof for sham transactions, right? Because now the word sham itself imports perhaps that a fraud is involved in some way, right? And so, but it's quite clear that there is no higher standard of proof for a sham transaction. You just have to show it on the balance of probabilities. And this was decided in the Able Lieutenant, right? Sham on the balance of probabilities and not beyond reasonable doubt.
Tian Singh, just a reminder, you have about 4 minutes left.
Wow. Okay, I've taken too much time then. Okay, very quickly. Okay, these are the factors which the courts have seen, right? Number one, right? So there's a Singapore case called the Min Rui 2016, in which certain factors were stated. Number one, the close relationship between the transfer and the transferee. Ocean Enterprise, directors in both companies were friends. Saudi Prince, the father's company, sold the ship to the son and the daughter's company, right? The Enfield, relevant parties controlling both transfer and transferee were the family members. In a case which I've done, which is the PDZ case, Dan Bunkering versus PDZ, the subsidiary transferred the vessel to the holding company, right? Number two, the completeness of the documents evidencing the sale and transfer of title. The bill of sale, right? Protocol, what we call the protocol of delivery and acceptance, under which one party agrees to divest title and transfer to the other party for all the, and from that moment onwards, the vessel becomes transferred, right? So was that document signed, right? Other documents, right? There are other documents which are generated during a transfer. The certificate of deletion, a deletion from registry, the change in the radio, the satellite communications, and so on and so forth. So you look at all the documents which are usually generated during a sale and purchase and ask yourself whether the documents which you see in your case correspond to those usual documents, right? Suspicious method and documentation used to effect the payment, right? In the Ocean Enterprise, a series of sham sales, right? In the Enfield, there were two bills of sale. There was one bill of sale that was not formally done properly, not legalized, but then, then another bill of sale suddenly appears, right? Set-offs, right, which may or may not be, correct, which you can then examine, right? Authority of the person executing documents, right? In one of the cases, the vessel was transferred to a company which had not at that time been incorporated. It was incorporated 1 month later, right? This is Yaskamolen, right? Right. The factors will consider to see the reality of the transfer of title. A lack of evidence of delivery, physical delivery. Was the crew changed, right? Price and other consideration. Was it at an undervalue? Right, you have a valuation of the vessel, and the sale was 50% of the value. Right, so that raises suspicion of that the transaction is a sham transaction. Right, a date of transfer in relation to possible claims against the vessel. Right, so if suddenly the vessel is transferred 1 week after many claims become obvious or many claims are being made. then you could put that into a mix as a suspicious circumstance, right? So in this case, right, you have the able lieutenant. The vessel itself had an outstanding mortgage of 10 million US. So they bought the vessel for 3 million with a mortgage of US 10 million. So the judge said, this doesn't look very commercial, right? And this is one of the things which was mentioned in that case, right? In the Yaskamolen, the company which bought the vessel was not even incorporated at the time when the sale was supposed to have taken place, right? In the Saudi Prince, the transfer was made by a company owned by the father into a company owned by the son and the daughter, right? And in that case, the evidence was the father could not even read English, and so all the transfer documents were in English, bills of sale and all that, and it was not explained by the father at the witness stand how he could understand all these documents and so on. It was also said in that document that in the sale transaction that the son and daughter paid for the ship by taking money out of their safe and then walking over to their father and then putting the money on the table in a briefcase, right? So yeah, so the court found that this doesn't seem like a real transaction, right? Then bunkering, at the time when the vessel was transferred from the subsidiary to the holding company, the subsidiary was insolvent. It was admittedly insolvent, and yet they still transferred the vessel. And it was found as well that the value of the vessel was low, right? Was about 50% what you would expect from the value. They took the net book value instead of the market value. No valuation was done. On both sides of the transaction, the same director signed the documents, right? There was one director for the holding company, one director for the subsidiary, and they signed both sides, right? And so there's quite a lot in this as well. In this particular case, we had to go through the accounting documents to prove that the company was insolvent, and also and in fact, subsequently, the subsidiary that transferred the vessel became wound up. Was wound up, and there as well, there were documents generated in the liquidation which we could look at and which could prove our case that the company was insolvent at that time, right? So here, dire financial position of the transferor of the vessel prior to the disposal, right? We had problems as well with respect to some the vessel was transferred at an undervalue. It was transferred very quickly. There was a settlement agreement, and 2 weeks later they transferred the ship, right? Transfer between two related companies with a common director, right? The documents with relation to the sale of the vessel, there was no protocol of delivery and acceptance, which is an important document in the transfer of the ship because it sets out the time and date at which risk transfers. And more importantly, the disposal of the vessel was an undue preference because the consideration for the transfer, moving from the transferee, was a set-off of certain debts. And so, but the transferor, by satisfying the debt to the transferee at the time when it itself was insolvent, constitutes an undue preference of the holding company as a creditor, as against the entire body of creditors. And the court found that, and it is deemed void under the Companies Act, under Section 528, right? That's it, right? So I think one last thing would be to say that there's no hard and fast rule on how you may be able to find that the beneficial interest has been moved in a sham or fraudulent transaction. A lot will have to depend on many factors, which call for a great amount of investigation. Right? Okay, thank you very much. I think I've run out of time, perhaps past my time as well.
Thank you very much, Tian Singh.
Over to you, Nathan.
Yes, over to you, Nathan. And while Nathan is projecting his slides, please be reminded that if you have any questions for the speakers, please drop them in the Q&A box. Tian Singh, could you stop sharing your screen?
I certainly will. If I know how to do it. Wait, just give me a minute. Stop share. Okay, that's it.
Right. Right, I'm gonna need some feedback, Trish.
Yes, I can see it clearly.
You can see it clearly.
Yes.
Fantastic. Right. Okay. I'm gonna start my stopwatch. I've been given 20 minutes, and 20 minutes it shall be. Good evening, everybody, and thanks very much, Tian Singh. Or Tian Singh, sorry, or TS as I always call you. Right, my name is Nathan Wheeler, and I founded a company called LSR Services. We're based in Hong Kong, and we deal with lawyers and P&I clubs, claims departments, restructuring, consultants, trade credit insurers, trade finance banks, in our role as investigators, corporate investigators, and due diligence providers. So our specialism has always been in shipping and international trading and cross-border litigation. So moving on from TS's excellent. Right. Okay. Beneficial ownership, as TS said, it's quite a complex thing, but we take sort of fairly broad approach to it. So I mean, we're not into the whole tax thing of it being a natural person. We'll take a natural person or a corporate body or anything else in between. And when we're looking at significant control and ownership, we're very broad as well. So I'm looking for anything where there's over 25% in this pure sort of shareholding capacity, but also other areas of influence, such as having control over a disproportionate amount of the voting rights, having control or influence over the appointments of people onto a board, and in fact the removal of people from the board. I'm looking at things like pulling up on the last sort of subject of undue influence over family members who happen to be on a board as well. And TS and all the law firm guys out there, clever guys, you know the law. I view it in quite a simplistic way, in that the lawyer has the gun and it's my job to provide the ammunition. And in terms of what ammunition that could be, well, ideally the silver bullet and a steady aim from TS, and we can get the job done. But equally, loading a shotgun with nuts and bolts, bits of gravel, and anything you can possibly get, ramming it down, and having a blast has potentially the same result. Throw enough mud, some of it'll stick, is the way we talk about it. Now, the application in the real world, and where I get a lot of appointments, is in asset searches. Okay, there's a problem with a ship, and there's a claim. The ship's gone, disappeared, nothing left. Somebody needs to pick up the bill. Who owns the ship? Who's responsible? Is it possible to identify another ship or another asset owned by the same principal behind the original source of the claim? So it's my job to go up the chain of ownership, and then down the other side, follow the lines of inquiry where they may lead, and hopefully find something useful to shovel across to my clients. But also something you may not have considered is sanction checks as well. So you need to get behind who you're dealing with in a maritime context, find out who's pulling the strings, because you don't want a rather distressing skeleton to jump out at some future point in time and embarrass one and all, and that can be extremely costly. So you need to look behind for matters other than pure sort of litigation and claims. And we also get involved in sort of shareholders disputes and insolvency and liquidations. And a typical case would be preferential creditors, where assets have been shifted out, sort of taking up on TS's example, and you know, given to somebody who's obviously, well, potentially related. It's just a case of proving who they are. Now, I think before we start, we got to quickly go through how people actually own assets and the means by which they do that. Trusts and foundations, it's a pretty difficult one to penetrate that. There's no specific register, and certainly the beneficiaries of trusts and foundations are sort of difficult to penetrate without some kind of court order. So for people like me, that's difficult. That's why we work in coordination with lawyers rather than for lawyers. I think the one we're all familiar with is companies. People own things via companies, either directly as a shareholder and with influence as a director, or via our good friends, the nominees, nominee shareholders and directors, who are all probably familiar with if we've had anything to do with Panama or Cyprus or things like that. People own things via property, via things that needs registration. So they've invested in things such as land and buildings, where you can pop along to some kind of registry office and see who owns it. Boats, cars, even racehorses. I mean, if you want to find out who owns racehorses in Hong Kong, there is a database where you can trace that. Usually worth a look for high-end or high net worth individuals. They like to splash out, but it's there. And people own assets via sort of expensive things that you don't have to register. So art and jewelry and bullion and things like that. And investments and portfolios. I'll have one of those one day, but usually through a stockbroker and people like that. Again, that's quite private and difficult to get into, and also via friends and family. So all of these areas you should have to consider when you're looking into who may own something and what they may own. And how do people construct these webs where they can link all of those things together? So here we would have a sort of typical thing. There's a bit of property and maybe some investments. That's a bank or maybe a company, but let's call that's owned by company A, and company A is owned by company B, but in a different country. And we have our good friends, the bearer shares, which still prevalent in Panama. If you hold a bearer share in your grubby little mitt, you are the owner of that share. You can keep it in your biscuit tin in the kitchen, under a mattress, or in your safe deposit box. But it makes it very difficult for people like me to tie you to that bearer share, especially if you keep moving. Of course, then the bearer shares could be owned by a limited liability company or held by a company in country B, and that company in turn is owned by nominee shareholders in another country and a trust. And there we are, Mr. Smith. Now, this is the creme de la creme of the setup, and we're into, I think, oligarchs and drug barons, if you want to go for this. But I think in the world of shipping, I think that is about as sophisticated as it gets. So you shouldn't really need to go too much further than the sort of LLC stage in another country. I'll just flick forward. Now, you need some kind of process to do this. And I would recommend this process. I mean, it's called the LSR methodology. I'm in 9 minutes at the moment, flying along. So the first one I would recommend is something where the value of the evidence is high. There's no privacy issues because it's public information, and you can sort of like trot along to court and use it quite freely. So governments or administrative bodies and registries, excellent place to start. Your ship registries, your corporate registries, your land registries, reliable stuff that you can use. Then if that runs, that doesn't give you your answer, then you're into other sort of like fairly public domain information, such as these items. And then if you're not getting much joy from there, you have to start the old plodding around on the phone, identifying people who've interacted with that company and say, hey, did you know these people? Oh yeah, the director turned up. I got his business card somewhere, yes. Oh, what's his name? You start building up get that little bit of knowledge that somebody knows from their interaction with that company. And now we're into stuffing the gravel into the shotgun stage. The magic bullet was at the registry usually. You get more and more information, and you get to grips actually with what the company is actually doing, which may lead you on to other areas to explore. You may think it's just a shipping company, but talking to people, it turns out to be a commodity trading company as well. And potentially that's more assets. Maybe there's another associated company that it's working with that through. So like potentially more assets again. You get the wider company structure, which then sends you back into the loop of more registry checks, checking again through the open sources, speaking to more people, and round we go. So that's the methodology I would recommend. So we usually get given things. It's a result of a problem with the ship. We have to go, get the sort of controlling entity, or trace a suspected owner down to a ship. I mean, usually it's a case of doing two things at the same time and hoping you meet in the middle. But just a word of caution. We often get instructed by clients who say, I know this guy's behind it, show me, make the link. It's always good to have a suspect, but be careful of taking the evidence that confirms your suspicion and disregarding anything that doesn't. You have to get all the evidence and come to a reasoned conclusion. Don't try and ignore stuff that doesn't fly with your particular theory at the time. You just have to play everything with a straight bat. So I'm looking at 13 minutes now, trotting along quite nicely. Okay. Now, usually it's the ship is the starting point. And ships give a lot of information just by their names. I think most people would be familiar with the heavy metal case, but that came down to the control exercised by nominee directors, I think, in Cyprus. But the ships were called Nirvana, Guns N' Roses, heavy metal, AC/DC, things like that. Call me old-fashioned, but there's a pattern emerging there. And people also get very, or in the old days, used to get very romantic about the naming ships. So look out for names of sons and daughters and cousins and things like that, or any particular pattern, and the pattern will bind those ships together and give you something to hold on to. And when we're potential sources for ships and a common control, a common mind, one single mind directing the operations and the destiny of that ship, then class societies will usually have a record of who the owner is in the widest term, or who directs them. And class societies are usually sort of have some longevity with them. They're there at the start and they're there at the finish, and you know, they tend to have to interact with somebody who has to make some big decisions about the life of the ship. Radio certificate, Panama, that's quite useful, because if there is a change of ownership, it can take a little bit of time to come through the system. But the radio certificate, for some reason, is there pretty quickly. Picking up on the customers again, you know, who are they dealing with the ship? Is it always the same guy, the same company that they're dealing with? Newswires and articles, I mean, definitely, if Tradewinds are naming some guy as owning the ships for the last 20 years, and he's giving interviews over the last 20 years, telling everybody that will listen about what he intends to do with his ships, then, I mean, that's evidence in my book. A joint entry with P&I clubs, funnel markings. It's all grist to the mill. I mean, if you have 5 ships wandering around the planet with the same funnel markings, it's difficult to argue that they're not under some sort of control. If only because somebody spent a lot of money on paint to do it. Okay, it could be a long-term time charter, it could be a bareboat charter, it could be the actual owner itself. But this is the type of information that gets handed over to TS to work his magic. Brokers, always a good source, chatty people, like a drink. And certainly S&P brokers, because when it comes to the sale of a vessel, that is a major decision that only the true owner, I think, would probably be in a position to make. So S&P brokers on that sake are quite a potentially good source. Actually signed contracts and things like that, which have some sort of legal standing. So bill of sale, TSA, and ship mortgages, which I'll talk a little bit more later. Hull and machinery, suppliers, same as the customers, and databases. I mean, I've seen an application for arrest in South Africa based solely on a printout from Sea Searcher and a couple of Tradewinds articles. And it flew for a bit. You know, a small amount will get you quite a long way. I wouldn't like to say that it's completely reliable, but you know, it's something. I want to draw your attention to 2 areas of special interest. I mean, flag registries, right? TS highlighted it. It's for us, it's our little sheet anchor. It's the one permanent thing that says that ship is owned by that company, and then from there we can spread out. It's rather frustrating when you can't get something from a ship registry, and because there's always that slightly sort of missing link and that slight uncomfortableness that you don't really know who actually is the registered owner of the ship. So you're working from not a solid foundation to make the great leap to who's pulling the strings. And mortgages. Mortgages are great. You can get them, and it's not just a transcript that says, well, they owe this amount of money to that bank. It's full of nuggets of information. It could be cross guarantees with other ships and companies. I've seen names of individuals as who have power of attorney. You have addresses where notice can be served. An address is always good to link up with other companies. Yeah, I've seen people sign as the directors of a Liberian company in a mortgage, and it's worth getting hold of. There's sometimes nothing, but very often quite informative if you can sort of go through it with a fine-tooth comb. And just a few sort of techniques. I often get asked about, well, oh dear, what do you do about a BVI company? Well, yeah, BVI companies, you're not going to get shareholders or directors because they're not required to disclose them. But a BVI company may actually be a subsidiary of another company, which is registered somewhere like Malaysia or Singapore or the UK, that has to produce financial statements. So it may be sitting around in that list of subsidiaries of that company in its audited financial statements. And you go, that BVI company is owned by that company. Fantastic. And away we go. And the converse, the bottom up is true. So the BVI company may own a company which is registered and providing audited financial statements in Singapore or Malaysia or the UK, for example. In fact, this bottom up thing cracked a big case for us. BVI company, we couldn't find it linked to any of that, but talking to people and going around the houses, we just got a sniff of a Hong Kong company, checked the Hong Kong corporate registry, and there we are with the BVI company being its direct shareholder. Thank you very much. $12 million assets, very happy client. Litigation records, these are great as well. They're getting a bit old now, but the Rule B filings in the US, there was so many going on. There was so much rich sources to be picked over, because people would turn up and say, I am this, I own this, these are my ships, this is how I do it, and these people owe me money, etc. So it's gone into court. They've said this is true, and as I say, getting a little bit old now, but it's a fantastic place to start. And once again, this helped us crack a really good case in South Africa as well. I mean, we went back to previous litigation where the guy was arguing one thing, and then of course, then when we arrested the vessel later on, he was trying to argue the other thing, and it just didn't fly for him. And here we are, the company corporate registry. Please don't ignore it. It's your first place to start. Other sources, we'll take anything. Brochures, websites. I mean, you could have a website claiming to own ships. It's difficult to say, well, that was just hyperbole. And also social media. Taking up on something that TS did. We had one case where a Chinese owner transferred all his ships to his daughter, but she, from her Facebook page, posting, seemed completely oblivious to the whole thing, and was busy living her life as she went on. But that was quite fortuitous. I think she perhaps learned her lesson there. And also the data leaks. I mean, these come and go. The information is useful for a short amount of time before people start reconstructing their positions. So in the real world, this is just a sort of a made-up sort of case, but if anyone's read the classics at Oxford or Cambridge, this is a Greek classic. This is how a Greek ship owner would typically set up his fleet. So we are, the rose, the daisy, the tulip. I see some kind of pattern going on there. Okay, 3 separate companies in Panama. But Panama registry is actually quite a good source. You do get board minutes, you do get directors, or sometimes they're nominees, sometimes they're not. Shareholders usually are a bearer share, but how do we make the leap to beneficial owner? Here we are. This would be a nice sort of typical case. So we have our existing structure there, and those items in sort of fawn color, rather fetching fawn color, are areas where we could potentially try and cross-check data to find some kind of links. So the additional bits to the previous page is the mortgage. So we would sort of like pull the mortgage documents on each of those ships to see what's in there, and often you get, you know, the legal guy from the ultimate owner or the sort of very close commercial management company sitting around in the mortgage signing things, and there you'd have your power of attorney, address, or directors. Maybe there's sort of cross guarantees going on there, linking all the ships together, because you've got to link the ships together as one entity. I mean, you can go that by going up and then going down, or if they all come together in a package like that, well, you just have to follow one up to the top. Now, in Panama, you do get board minutes, and the board minutes are usually result from some kind of you know, change of board composition, which does happen, and quite often the address of the place where the board meeting apparently took place is inserted. I've seen, you know, proper addresses from the suspect companies inserted into those minutes. Now, each of those ships would have the contract with a commercial management company, which would be maybe Panamanian or Liberian. But in the case of a Greek owner, I've never come across a Greek owner. In the case of a Greek owner, then that management company would probably operate under law 8967 from Greece, so which is a tax efficient scheme whereby companies registered outside Greece can operate inside Greece if they register. Now, if you are serious about trying to make the link, then you can apply to the Ministry of Transport in Greece to get copies of the board minutes from the Law 8967 filings, and this is all to do with tax. And you may be able to pick out names from there, such as directors, and maybe people, you know, sort of disclosing that they're owners and addresses, and then perhaps link them to the board minutes at the Panamanian registered owning company level, and then even further down into the mortgage, and make a more solid case for a group of companies acting in unison under one controlling mind. So that's a fairly simple representation of what can be achieved. It's a big subject. You know, we get asked to do this for a multitude of reasons all over the world. Brass plates, so Liberia, BVI, quite typical regimes, and it can be done if people are careless in the way they've structured their companies. I think if people take a bit of care in structuring them correctly, it can make it extremely difficult. But do people care that much? I think it's usually driven by tax avoidance rather than a big effort to conceal identity, unless it's a purely sham transaction, of course. But I think I've used up my time. We've gone overboard on that one. Sorry about
thank
that,
you very
Trish.
much, Nathan. It's fine. So we have run out of time, but perhaps if you don't mind, maybe we can take one or two questions from the audience. So Tian Singh,
Yes.
there's a question here. If it is a maritime lien claim, does it matter if the transfer is a scam?
No, because the maritime lien would travel with the new owner, right? So it travels with the ship. You know, no matter how many how many sorts of ownership changes that they go through. So let's say, for example, a collision claim or a crew claim, those are maritime liens. I mean, that would travel with the ship into the new owner.
Thank you. And Nathan, a question for you. So what are some of the jurisdictions where you have encountered the most difficulty ascertaining the true beneficial owners of vessels? And what would your advice be when dealing with ownership issues in those jurisdictions?
I think, well, the classic ones we always get are offshore registered locations such as BVI and Liberia, where you just don't get directors and shareholders. So it's always difficult with that. So we have to go use the methodology as I described earlier. The frustrating places are the places where I can't get the registered owner of the vessel set in stone. And so certain flag registries will not give you that. I suppose China being one. And I think other places are extremely difficult. Some will give it to you over the phone, but okay, at least it gives you somewhere to start, but, but that's about it. Yeah, I think we're just used to it being very difficult. It's usually the scenario that makes it more difficult. So if a company hasn't been in business very long, if its interactions with the outside world are limited, maybe it's only done one transaction and that's the thing that has caused the problem, then the number of sources or potential sources that surround it are limited as well. So I think that's the scenario which makes it most difficult.
Excellent. Thank you very much, Tian Singh and Nathan, for your time and for your insightful sharing. We've unfortunately come to the end of this webinar. I see that there are some questions which are still unanswered. We will email them to the speakers, and Tian Singh and Nathan, if you don't mind, you could email the participant directly on that.
Yep, no problem.
Thank you again, everyone, for joining us, and stay safe, and I hope to see you at the next IMSML webinar. Until then, take care. Bye.
Good evening. Bye.
Thank you very much. Thank you. Bye-bye.
Bye. Thank you.